out here for this event, so we won't take up much time. We'll get right to it. What I've asked the candidates to do is to give about a 5 or 10 minute talk about who they are and why they're running for this office, and then we'll open it up to questions. And if you got questions, raise your hand, and I'll just act as a moderator and point out, and we'll go from there. All right? Okay, you want heads or tails, or?
Heads or tails is good.
All right, go first.
All right.
There you go. You won the toss.
She that opens her mouth first talks first. Good evening, everyone. I'm Judge Susan Theall. It's an honor to be here tonight, and thank you all so much for coming by. I've been the family court judge for the last 3 years. On December the 2nd of this year, it'll make exactly 3 years since I've begun serving as family court judge. Prior to that, I was a board-certified family law specialist for 20 years. I've actually been licensed to practice law for 29 years, and my entire professional career has been devoted to this area of law. The very first case I tried as a lawyer was a custody case, and I saw how I could have a positive impact on children's lives and on families' lives. Now, getting back to being a judge, since I've become a judge, it's been exciting. I've really enjoyed serving our community. I will tell you that in 2012, the Louisiana Supreme Court chose me to be part of the Judicial Leadership Institute. And I see Judge Francie Bouillon, who's a city court judge, who was also part of the Judicial Leadership Institute. There were only 30 or 40 of us, Francie, chosen from the entire state to participate in this Leadership Institute. And thankfully, the Supreme Court recognized both Judge Bouillon and my leadership skills because I've always been a leader. However, it was a process through the year to go through the Leadership Institute, and again, I feel like I really benefited and was able to bring some of my skills to our community because of the training that I received from the Supreme Court. In 2012, I used some of that leadership ability and some of the thinking outside of the box that I possessed to start a new program that at the time we called Clear Start, but which is now referred to as Kids First. I saw that there were numerous problems in family court where parents could not take care of their children because they had substance use issues. Originally, we started the program with drug abuse, and it's more than just abuse of prescription pills. We saw things like parents smoking crystal meth. We heard about heroin use. We heard about some really extreme behavior. And our research shows, as well as practical experience, that parents who are abusing alcohol and drugs can't take care of their children. Because that's what I was seeing in family court. Those parents are the ones who didn't get their children to school on time. They're the ones that didn't make sure that their kids did their homework. They're the ones that didn't allow their children or didn't encourage their children to participate in extracurricular activities. As time went on, we added alcohol to the program. A 12-year-old girl testified in a trial, and she's making A's and B's one semester and C's and D's the next. She was always on time at school in the next semester. She had been absent or late 12 times. And I said, "Baby, what's going on?" And she said, "Well, Judge, I don't want to tell you." And I said, "Well, look, the grown-ups can't decide where you're going to live, and so you need to tell me so that I can help you." And she said, "Judge, my mama gets so drunk every night because she's so depressed that she passes out. And when I wake up in the morning, I have to make sure that she's alive before I go back to school." When I heard that, I realized that we had to add alcohol abuse to our program. And so we had, from May of 2012 through the end of May of 2014, 300 parents came through the program. The program was run through my office as an experimental basis to try to make sure that we were doing the right thing. And in fact, in June of this year, the judges approved hiring a coordinator. So we now have a coordinator, and now we can take this program to the next level. So it's something that I'm very proud of. I'm also very proud of what I call the self-represented docket. The Louisiana Supreme Court has encouraged judges to provide access to justice to everyone. The courts that are not open to everyone and that don't provide justice to everyone are not fair courts. Chief Justice Bernice Johnson of Louisiana Supreme Court recently sent something out to all the judges saying we have to provide access to justice. So I have what's called a self-represented parties docket, and it's for people who can't afford lawyers. It's for people who were coming to court afraid and unable to open their mouths to try to represent themselves because they weren't lawyers. And so what I did is I created a special day for those people so that I could help them get the help they need. And they had the same sorts of problems that everyone else had. They had issues with custody, they had issues with child support, they had issues with substance abuse. But they could use their own petition, they could write on a piece of paper, and they could come to court, and we could swear them in and try to solve those problems. So I'm really proud of those two particular programs. Also, we've tried to do as much as we could to improve family court. I will tell you that our family court in Lafayette is state of the art. The other judges call me constantly and say, oh my God, I'm getting calls from judges all over the state wanting to know what Theall is doing in their court because they found out about our substance abuse program. They found out about our self-represented docket. I've had other judges from around the state come and observe the self-represented docket because the Louisiana Supreme Court has a committee called the Self-Represented Litigants Committee where they encourage judges to help people who cannot afford lawyers, but no one is quite sure how to do it. And so I at least took the step to make an attempt to do this, and I think that it's working really well. It also reduces some of the waiting time for lawyers and litigants on Thursdays. Our Thursday rule day in Lafayette is the busiest rule day. The other thing that we've done in the family court is to meet frequently with our hearing officers. We have 4 hearing officers who are lawyers who help the family court judges try to move things more efficiently. My vision for family court when I started this 3 years ago was where people could be treated fairly, with dignity, with respect, and where their matters could be moved quickly through family court. Because again, experience shows us that if your matters are not handled quickly, things become acrimonious, people are angry, and what happens when parents are angry with each other? Their kids know it, their kids feel it, and their kids suffer. So what we're trying to do in family court is move things as smoothly and as quickly as we can. Towards that end, we have tried to increase efficiency with the hearing officers. We meet with the hearing officers every other month to try to encourage them, to try to set higher standards. Along with that, Judge David Blanchette and I are both board-certified family law specialists. Our chief hearing officer, Vanessa Randall, is a board-certified family law specialist. We have a recent hire that we're going to ask that he become also a board-certified family law specialist. And for those of you who may not know, there are only 92 board-certified family law specialists in the state. It means that we have a particular knowledge and training that has been acknowledged by the Louisiana State Bar Association Board of Legal Specialization. So in closing, because Paul is giving me eyes and giving me hands, I will tell you that my entire career has been devoted to family law. It's the area of law that I love. It's the area of law that I'm good at. It's what I have chosen to do to try to serve our community. I believe all of us owe service to our community. I've been deeply involved in our community by sitting on boards, on the board of Faith House. Oh, and I forgot. The Louisiana Supreme Court also appointed me as a domestic violence trainer. Judge Blanchette is also on the Louisiana Supreme Court Domestic Violence Education Committee. And so again, our court is recognized throughout the state as specialist. We have something special here in Lafayette. I do want to continue to serve our community. I ask that you please seriously consider my qualifications, and I ask for your vote on November the 4th. Thank you very much.
I want to start by thanking the Fontanas for the invitation and for hosting this event and for really caring about politics. My name is Charlie Fitzgerald. I'm running for Family Court Judge, DivisionM. During the campaign, I'm always asked, who are you? Describe yourself. And my response is always, I'm a Christian, I'm a husband, I'm a teammate of 10 years, my wife Jean, sitting right here, and I'm a father. We've got 3 children, Patrick, 8 years old, John Henry, he's 6, about to be 7, and Annalise. She's the boss, she's 5. When we were at Scott, about Annalise, just a quick aside, I made a comment, I was introducing the family to the Scott City Council. And I did, I said just that. I said, here's Annalise, she's the boss. For 2 weeks after that, at home, that she'd walk around, I'm the boss, I'm the boss, I'm the boss. And so as parents, we learned about kids that we're constantly in the fire and we constantly are in the struggle. We understand the awesome responsibilities and obligations associated with parenthood. It is a non-stop 24-hour day job that does not have a checkout clock. Why me? Experience. Okay, professional experience. Let me touch there first. Lafayette's always been my home. 1992, I graduated from the Episcopal School of Acadiana. Thereafter, I went to LSU where I graduated in microbiology, and then I went to law school. Graduated in the top 5% of my class. From there, I first started at the biggest firm in the state, Jones Walker. Still is the biggest firm in the state. I was there 2 years doing corporate litigation. In 2003, my partner Rodney Cox and I, we started Cox Fitzgerald. Okay, for 11 years, from its inception, Cox Fitzgerald has been a family law firm. Family law, well, what does that mean? What does a family court judge do? Family court judge, specifically the office I'm running for, these are the divorces with kids, the divorces with custody. That every case you deal with minor children, your judgments affect their well-being. When we started Cox Fitzgerald, we started it just exclusively to handle family law cases. Since 2003, January 2003, through the present, I've handled over 800 family law cases, whether as lead counsel or as a senior partner advising junior associates. I've mentored 5 attorneys in the field of family law. In addition to that, I lecture on family law. I've given lectures and presentations to the Society of Louisiana CPAs, to the National Business Institute, and to the Lafayette Bar Association. On December 16th, I'm going to be in Baton Rouge lecturing on complicated community property partitions. December 17th, I'm committed to lecture in Lafayette, same subject. Legal organizations and affiliations. Before I get into this, because the first one, I have all these federal court certifications, I'm probably one of a handful of attorneys to ever handle international abductions, international kidnapping cases. In 2009, I had one that I handled in the federal court. It's a reported opinion in awarding judgment in favor of my client, awarded me attorney's fees, $15,000, and he noted, based on my extensive experience in family law, that an international abduction case, it's about as serious and contested as it gets. In addition to that, in terms of federal court, I'm one of the very few attorneys that's actually, in family law, that is certified to practice before all federal district courts of Louisiana. I'm certified to practice before the Federal Fifth Circuit. I'm a member of the Federal Appellate Bar Association, the Federal Bar Association. I'm actually certified to practice in the bankruptcy court for the Western District of Louisiana. I'm a member of the Louisiana State Bar. I'm a member of the Lafayette State Bar. I'm a member of the Lafayette State Bar Association's, or the Lafayette Bar Association's family law subsection that and I have since we started Cox Fitzgerald. What I just highlighted there, okay, my professional experiences, that's the mechanics, the procedure, that's the technical stuff you learn in class, the stuff you learn in private practice. You read about kids, you read textbooks, talk to professionals. There's an added element that I think for this position that's actually more important than professional experience. It's life experience. Life experience. As a husband, I know what it means, the ups, the downs. I know what it means to go to bed at night and not being able to apologize to your wife about a fight, and you don't have the vocabulary to express how you feel and how much you love somebody. I know what it means to be a parent. I know what it means to love kids more than your own life. I know what it means to have a profound understanding of unconditional love. I'm in the struggle. I'm in the fire. I came from a broken home. When I was in 6th grade at 11 years old, I got the news, and I remember to this day where I was. My parents aren't going to be back together. I asked my mom, is Dad coming home? Her response was no. It was the worst day of my life. For a year leading up to that, divorces don't happen instantaneously. You can tell as a kid what's going on. It hurt more than anything I could ever imagine. This is really the first time I've ever talked about it to anybody. That the effects of that thereafter solidified in me that when I was married, that would never happen in my family. I understand what those kids go through. Again, when you're making judgments and you're adjudicating the well-being of those kids, your judgments affect them. You better have some empathy, and you need to have that understanding in order to render these judgments. That I am happily married to John. Our family is intact, and I'm very proud of that. But it is, as any parent knows, it's a non-stop struggle. Again, why am I running? Why am I the candidate that I would ask for your vote? Experience, professional experience, and more importantly, life experience.
All right. Open it up to questions. Anybody have a question? What we'll do is you ask a question. If it's for one, we'll let that person answer it, and then we'll let the other person have a time as well. So, and we'll limit their responses to about 2 minutes. So, any questions from the audience? Otherwise, we'll have a very quick meeting. Yes, sir. How about you?
Judge, you had
Yes, sir.
mentioned something about the substance abuse program that y'all started. Is that mandatory or voluntary?
It depends.
I'm going to follow up on
Okay, that's fine.
Well, I'll sit down.
That's fine. Under our revised statute, if there is a rule to show cause why someone should not be evaluated, that comes to court like that, okay? So if someone can show that there is substance use, and if I hear the testimony that there is substance use, I can ask that they enter into the program, or I can order that they enter into the program. I can also ask that they get private treatment, or I can order that they get treatment, and in default of which, in other words, if they've got a problem, I can suspend normal visitation and only impose supervised visitation. Yes, sir, I see a confused look on your face.
No, no,
But
no,
that's the
I'll-
only way that we can try to ensure that parents who have problems get the help that they need. So it's by a rule to show cause. So for instance, you're the dad and you believe that your ex-wife is using drugs or alcohol. You would have to have your attorney, or you would have to file yourself a rule seeking an evaluation. And then that would come to court, and you would have to prove or present sufficient proof that there is a problem for us to consider it. Does that answer your question?
First part of it, yes. Let's say that happened, and the party that you either ask, I don't know at this point, it sort of falls apart, I don't know, that you ask to go into the program, or that you mandate go into the program, refuses to do that. What happens then?
So if there is a problem, I can order, and sufficient proof has been produced in court, I can order them to undergo an evaluation. I first ask. Generally speaking, most of the lawyers who come into court and know that their clients have problems say, yeah, you know, I know we need to get something done. So if they refuse to consent to an evaluation, I order the evaluation. They can either do it through the court program, through family court, or through another program. If they refuse to be evaluated after I have heard sufficient proof that they are either getting drunk to the point that they're passed out every night, or that they're smoking crystal meth, because amazingly a lot of people simply admit what they're doing. But if they refuse to go through the proper evaluation process to find out if there is a problem, I do suspend visitation until they agree to get the problem addressed. Because if you don't do that, you're putting children at risk.
So if you've been evaluated and you mandated or told them they've been evaluated, they don't
Right.
refuse that.
So if
And they
they've been
refuse
evaluated
after.
and there's a problem, Is that your question? What
There's a
happens?
problem after this that he doesn't want to, I think they're supposed to go check in and get tested and things like this. What happens at this point when they don't want to participate anymore after they've been evaluated, instructed to go through the program?
Okay, so for instance, again, you and your
Sorry.
ex-wife, no, it's a valid question. Someone asked you to ask it, and that's good.
No.
So you and your
No, I'm asking it from,
Okay.
I didn't realize, the only reason I'm asking is because you brought something up, and I
Okay.
just want to understand the program.
Okay, so here's how it works. The first step is to evaluate. As part of the evaluation process, each person who is accused of abusing substances, after I've heard the evidence, has to meet with 3 different people. And we set the program up like that because often addicts refuse to acknowledge that they have a problem. So we didn't want someone saying, Steve interviewed me and he just didn't like me. So instead they go interview once with Steve, once with Savannah, and once with Stephanie. So over a 4 to 5 week period, they interview with 3 different people. There are 2 tests. One is subjective and one is objective. And then throughout that entire period, they are randomly tested to see if there are any substances on board. We have 2, the testing that we do tests for both alcohol and illegal substances. Actually, it tests for any substances because, for instance, there are many people who
You
test
need to wrap
positive
this up a
for
little.
hydrocodone and they don't have a prescription.
If you refuse to take the test,
If you refuse to take the test, it is up to your lawyer to file a rule to show cause why visitation should not be suspended because either they refused or they took a test and were positive. So it's a
Thank you.
pretty extensive program, and apparently we don't have enough time to explain it all, but it is on our website, www.15jdc.org. Click on the Family Court link. There's a booklet explaining all of the procedures, and there are also forms.
Charlie, you know, talk about that, or?
I do. This isn't rocket science. It's pretty simple. If you have a parent who's using illegal drugs, you suspend or you supervise that visitation immediately. Then I don't need a study to tell me that a parent who's doing crystal meth may have trouble raising children. Of course they are. That if they're doing drugs, if they're inebriated, you don't need an assessment. Immediately you order, supervised visitation. You got to have those kids with an adult that's sober. And so that it again doesn't take that deferring somebody to a website, to come to these conclusions.
Yes, sir.
Earlier in the week, we talked about what your plans were for the court. And you'd indicated that you were looking, one of the first things you were going to do is to shut this particular program down that's being discussed. And that you were also going to eliminate, I think it's a self-representation docket. I'd ask you at the time, okay, well, that will take a short period of time. What are your plans to fill the void after that? And I understand what you're saying here, but sometimes when you're not just dealing with a child, but you're dealing with 2 angry adults, okay? You need more information, and in some cases, even a cooling off period. So between the time we last talked and now, have you reconsidered shutting both of those programs down? And if so, what are you going to replace them with, if anything?
In response, that I've never said, this is our 3rd debate this week, that what I talked about shutting down was essentially this pro se docket. Let me explain what that is first. Pro se docket, that my opponent has mentioned, well, that I'm the only one in Louisiana, the only judge that has it. Well, there's good reason, because it limits pro se litigants to court 1 time a month. It's not fair to them. You're talking about people that lack resources to even hire an attorney. If you all of a sudden take them off of a Thursday rule docket, we have multiple Thursday rule dockets per month, and you then relegate those cases to a Monday, 1 time a month rule docket, you're limiting their accessibility. Of course that's why we shut it down. They should have access to the court all the time, okay, not just 1 day a month. In addition to that, going back to the drugs, my concern with all of this is that we're painting with, we're losing sight of the big picture. Okay, well, what is the big picture? It's the best interest of children. It's protecting children. According to our Supreme Court, that a family court judge's responsibility is to act as a fiduciary to protect the children, their best interest. Not every case has drug issues. Not every case has alcohol issues. Okay, some cases do. The 19th Judicial District Court that did specifically out of East Baton Rouge Parish, what they have in their family court right on the same floor is a drug testing system. You can easily do that here. In other words, if there's an allegation of drug use, within an hour, you get the results right back. If it tests positive, you know what? You don't need a program. Immediately, a judge can take action to protect the children. And so, again, what I'm talking about is saving costs, saving time. Ms. Theall mentioned essentially that one of the worst things about cases, it's if they drag on, the length of cases, increases animosity. Let me tell you something. If a case gets in front of a family court judge, there's already animus. There's already tension. The parents already can't stand each other. Okay, the judges don't see the good cases. The good cases settle. You see the worst cases. And again, you have to make decisions and make decisions quick to protect the children and make decisions that are at the end of the day, practical and hopefully promote a facilitation between the parents to communicate about the well-being of the children. And so, but again, it's not the parents. We have a drug court. I'm not running for a drug court. I'm running for family court judge. Okay? That not every case that again involves a drug issue. In fact, it's an extreme minority. And so that hopefully that answered your question.
Not quite, because I've looked at all of the video that's been shot during the week. You did say that you were shutting both programs down. Okay? But, I mean, I read them. I looked at the video.
Well, you're the videographer.
But what I'm saying is, but
You
you said
missed Theall's
you
videographer.
were not going to shut them down. Okay? So you actually said you were going to shut them down. Now, to finish this,
We went through this last time on Monday.
We're not gonna have pointed questions that are trying to put it.
I'm just simply saying what I'm saying, what you're telling me then, is that the programs are not necessary and you're going to use testing as you described.
It's every case. The interesting thing about a family court case, and the reason why I think that you have to have life experiences, is because every case is fact specific. There is no one case fits all. Okay, depending on the factual circumstances of a particular case, clear start may be a good thing. What I'm saying is that you don't. Let me back up a little bit. A trial judge, family court judge, you've got to make decisions. When you start setting up all these programs, you start allocating responsibility everywhere else. Guess what? As a judge, the buck stops here. The judge has to act. The judge has to react based on the specific facts in front of them. Again, there may be certain cases where clear start is good. I'm just saying it doesn't have to be as convoluted, as complicated, to where even somebody like Mr. Guidry can't even understand my opponent's explanation.
You made it clear from this is clearing up some of the things that you said on Monday. I just needed to get it cleared up.
I'd appreciate a copy of the video.
Be glad to get you.
Susan, you wanna?
Certainly. Well, number one, drug court doesn't handle family law cases, doesn't handle divorces. And so, to talk about drug court instead of our program in family court kind of gets you off track. I will tell you that over the last 2 years, I had close to 1,700 new cases assigned to me. Now, that's not all I heard in 1 year, but close to 1,700 new cases assigned to me. Of those cases, 300 families had drug issues. So it is a common problem. It is a program that's needed. Mr. Fitzgerald talks about Clear Start. Well, Clear Start was from May of 2012 through May of 2014. The program is now called Kids First because we've improved on it. And the reason we call it Kids First is because we encourage parents to put their children first and not their desire for drugs or alcohol, because that's what we're seeing, and it's those children that are suffering. He also talked about we can do something easier by just having someone test the parties as they leave the courtroom. We do that now. Mr. Fitzgerald is not practicing law this year, so he doesn't know about that. But with our new coordinator, we have the ability to test parents instantly. Through programs with the Sheriff's Department, we also have the ability to test people instantly. Interestingly, And I see there is one family law, two of them here, Mr. Meir and Ms. Hurst. Most of the lawyers who have filed a rule to show cause for drug testing have bought into the program. And why have they done that? Because it's a good program. We've done a really good job with it. We've addressed a serious need in this community. We have tried to get parents off of drugs so that their children don't suffer.
Okay, any other questions?
Yeah, I'd like to address this to Judge Theall.
Yes.
Is the Clear First program the same personnel you had in Clear Start?
There's no Clear First program, Mr. Fitzgerald.
Okay, well,
It's
what is
called
it now?
Kids First.
Kids First. Okay,
Correct.
is the same personnel do the evaluations?
The assessment, the initial assessment is done by Melissa Arsenault. Then we refer it for further evaluation to either the personnel at Clear Start. We sometimes also refer it to people through the Sheriff's Department.
What are the qualifications of Ms. Arsenault?
Ms. Arsenault is simply the coordinator, so she's the case manager. She's been trained in what's called the Texas Christian University Screening Instrument, and it is an assessment tool to find out if there is any propensity for use. She also takes them and makes sure that they are drug screened. She inputs the information into case manager, the Louisiana Supreme Court drug court case management software. And so she tracks basically all of the information. She's a coordinator. She's mostly secretary.
Recently, she was a secretary in the hearing officer's office. Is that correct?
That's correct.
She is not a board-certified substance abuse counselor or any of that.
Well,
She's
if you
just
were
a
listening
screener.
to me, if
I
you were
was
doing an
listening to you.
active listening.
I was listening.
No, you're not.
Yes, I am.
She is the coordinator. She does secretarial work. She inputs data into the Louisiana Supreme Court drug court case management software. She has training in a TCU screening instrument, but she is the coordinator and she is not a substance abuse counselor. Those people, when we do the actual evaluation, go to Clear Start, the same people, or through the Sheriff's Department, because the Sheriff's Department has some incredible programs that are free to the public.
My question was simply, the people that do the evaluations for substance abuse problems used to be with Clear Start. Are these same people doing the evaluations for the court?
Yes, they are.
you-
Dwayne and Chuck.
Wayne and Chuck, are you aware that neither one of them have advanced degrees? You're putting a premium on certifications, that's why I'm asking.
Because they are certified, they are licensed substance abuse counselors.
But they're not,
And-
they have no advanced degrees.
No, they
Are
don't.
you aware of that?
I'm aware of that.
Thank you.
Next question.
But they do a really good job. Thank you for your points, Mr. Fitzgerald.
Anybody else?
This is a question for both of y'all. And I'll just start off by making a statement so that you understand the question even better where I'm coming from. I'm the blessed father of 5 children. Went through a very painful divorce, toxic at times, that took way more time than any reasonable person should ever have to go through. Both parents, myself, my ex-wife, and certainly the 5 children. I can tell you that after 4 years, my children are finally learning to live their new normal. A normal that consists of their father being their sole custodian, and if I will, Mr. Fitzgerald, take one that truly understands 24/7. I do it on my own, as I think you're aware. That normal doesn't really necessarily consist of their mother because she moved away 3 years ago. My question is this. What are you going to do to limit and stop the lawyers from continuously delaying trial dates and court appointments for unnecessary reasons? And I'm going to go further, and the reason I ask this is this. Everyone on both sides starts off on day one. This is what I heard. We need to do what's right for the children. And boy, you hear it, and it's instilled, and it's hammered in there. Let's do what's right for the children. Well, after 3 or 4 years of litigation and all that, I can tell you, my children, it was not being done for the children. Okay? So what we do have, in fact, what really happens is typically You have one that's trying to self-benefit from a settlement. You hear all the horror stories and those kind of things. All along, the children are being emotionally tortured.
Okay, so your question is, how are they going to speed this process?
How is the process going to speed up? But in particular, how are you going to control the attorneys
lawyers.
from unnecessarily continuing every case and every document and every trial date?
Gotcha. Charlie?
I am aware of your case. And it's interesting that you brought it up. I represented your ex-wife. That in that case, that you were held in contempt. In that case, that I never moved for continuance. In that case, there was a settlement. The judge was David Blanchette, who was wonderful. That we settled, and it was shared legal custody. That I withdrew at that time. I don't know what's happened in your case since then. In terms of speeding it up, I'm running for DivisionM. What would I do to speed up court? I would start court earlier. I would eliminate smoke breaks. And the pretrial conferences would be held in the courthouse, not outside, so a judge could take a smoke break.
So what would you do, from what I understand the questions, if the other attorneys keep asking for continuations or whatever, what do you do to speed that process up?
Well,
what can you do as a judge?
Scheduling orders. And so we have rule dockets and then we have trial dockets. This gets a little bit technical, but if you file, for example, in your case, a custody action, it's originally set on a rule docket. Well, if you know that you're going to have witnesses, if you know it's going to take more than 3 hours, the judge should then immediately meet with the attorneys and schedule it on a merits trial date. When you do that at the same time, you issue a scheduling order. In other words, you set up incremental deadlines, and then included therewith, you have status conferences with the court to make sure that we're on the same page, make sure that discovery has happened, make sure that there are no delays. And if you do it that way, you can identify if there is any dilatory action, and you can act accordingly. And acting accordingly would mean denying a continuance motion sometimes.
One of the solutions, Matt, is to have case management software. Again, the Louisiana Supreme Court has encouraged different judicial districts to start experiencing with or experimenting with case management software. We are, again, one of the states that lags behind everyone else because we have not started experimenting with this yet. I will tell you that with our hearing officers, because you're aware of the process, a petition for divorce is filed. The first thing that happens, it goes to a hearing officer, and that's a lawyer who tries to have a conference with the parties to try to help them resolve their issues. What we found has been happening is lawyers were asking for 2, 3, 4, 5 continuances just at the hearing officer conferences. So we're in the process, and in fact, we should be able to go up with it in the next 2 weeks, new case management software, which will track what's happening through the hearing officer process, and we're going to limit the number of continuances that can be requested. We're also going to try to take that into court so that we can try to track cases. And I'll tell you, Mr. Fitzgerald talks about scheduling orders. We do that already. But the problem is that lawyers are trying to juggle a lot of things. And so sometimes they request continuances. And once maybe you can understand it. But if in fact it took your case 3 years to work its way through the system, that's too long. You know the harm and the damage that it did to your family and to your children. And so again, as I said when we started, the object is to try to move cases through court as quickly as possible to put a resolution so that the parents quit fighting and so the kids can be kids and quit feeling the tension and anger between their parents. In the future, in fact, Judge Blanchette and I, we meet with the hearing officers regularly. We have plans to change our local court rules. There are going to be stricter deadlines. We have to publish it so all the lawyers know about it. So we are taking steps to try to make things move more quickly through family court. Mr. Fitzgerald talked about pretrial conferences. Right now, I get into the courthouse 7:30, 8 o'clock before a rule starts at 10 o'clock. 10 o'clock is a traditional time for rules starting, and I have pretrial conferences every rule day before we even start. There are also times prior to the rule day where I'll have pretrial conferences, because the whole idea is to try to get parents to resolve their issues without having to come to court. I tell parents all the time, one more second, don't let a stranger make decisions about where your children are going to live. And I'm a stranger. Do everything that you can to try to resolve this case so that your children don't suffer.
Any other questions? Yes, ma'am.
Mr. Fitzgerald, I've been to all the forums, and without fail at each one, you refer to Judge Theall as Miss Theall. You're running for judge, and while we may not like a particular person, may not respect, or whatever the term may be it a senator, the president, whatever, respect for the office should be given. So my question to you is, if you were running against, let's say, Judge Doherty, or Judge Conk, or Judge Rubin, Judge Edward, anybody else, would you refer to them as Durwood, Mr. Conk, Rebecca, Ms.
I'm
Doherty?
gonna stop that. That is not an appropriate question. We talk about the president as Mr. Obama.
I would like to answer.
All right.
When I'm elected, the only time you call me judge is when we're in open court. Outside of court, I'm Charlie Fitzgerald. You betcha I'd call Jim Doherty Mr. Doherty. You betcha I'd call Durwood Conk Mr. Conk. And I know you're invested with Ms. Theall because you're her court reporter, but that's exactly what I would do. We're outside of court. There's no need to wear a robe outside of court. There's no need to throw around the judge term.
Another question. Yes, sir.
I wasn't at the other debates or what have you, but in case it was already answered, where do we see like the largest? Where did you see like your greatest accomplishment, I guess, in your term, and where do you see your biggest hurdle going forward? And I guess Charlie, if you're elected, what would be your biggest like initiative? I guess is the gist of the question.
All right, 3 minutes, Susan.
Oh, come on, Paul. You know I like to talk. Okay.
I know.
We're not going to talk about greatest accomplishment, but I have to tell you, I'm proud of the program that we've got called Kids First, because for the first time ever, we're addressing on a consistent basis parents who have substance use issues, both alcohol issues and drug issues. Again, I've got to tell you, I'm very proud of the program that we have called the Self-Represented Parties Docket. Mr. Fitzgerald said earlier something like, well, I'm limiting people to only 1 day a month, and that's not correct. We have self-represented parties on each Thursday docket because there are always exigent or emergency matters that come up, and so those are not made to wait. However, the majority of things can be set on 1 day, because what happens if you try to hear it on a regular rule docket, someone who is not a lawyer, who doesn't know how to verbalize what they need, it really takes a lot of time. And what happens is then you've got clients who are paying their lawyers to wait, and it really makes the entire day drag. So it was better for the public to put those self-represented people on their own special day. So those are two of the things that I'm very proud of. They've been recognized and acknowledged. I think they ought to be continued. Project in the future, we've got lots of projects in the future. I've got lots of ideas. Judge Blanchette and I meet regularly. We are trying to change some of the local court rules to make things run more efficiently, more effectively, and I'm looking again forward to serving the public for the next 6 years.
We talked about earlier, and I mentioned adopting something similar to the 19th JDC, the East Baton Rouge Parish, about the instantaneous drug screen. Ms. Theall commented that, well, we have that now. No, we don't. That, in fact, the order is that 24 hours. When 24 hours, what happens is people shave their body hair, they bleach their hair. It happens all the time, and it's a reoccurring source of frustration. That's why you would have it where you can test within an hour. They can't go anywhere. And so that you get the test results back. That way, if they test positive, immediately you can take protective measures. The big picture, again, it's protecting children, not just these drug cases. At 17% of the cases last year, according to Ms. Theall's own numbers. The big picture, protecting children. Every case is fact-specific. And so whenever, let me back up a little bit, whenever the decision, I was approached by a number of attorneys back in March. And essentially, it was that you need to run. If not you, who? That my response was, give me 1 week. My wife and I will do a whole lot of praying, and we'll give you a definitive decision. We did. When we made the decision, we committed to restoring honor and dignity and impartiality to this division. One policy I'm going to eliminate immediately is this Gold Star policy. Okay, they're in open court on Thursdays, and I've been there, that preferred attorneys are pointed out by Ms. Theall, given laudable accolades, and then referred to as Gold Star attorneys, and even on occasion given Gold Stars. Have I complained about it? You bet. I complained in open court because it is wrong. That policy never, ever should have been put in place. A judge has to rule each case without bias or prejudice and apply the law and treat everybody with dignity. That was wrong. That policy will be eliminated effective immediately.
Do I get to respond?
Sure.
Okay. Well, as I said Monday, Mr. Fitzgerald was just disappointed because he didn't get a gold star. It was a lighthearted attempt to try to motivate lawyers. It was a lighthearted attempt to try to motivate lawyers to get them to do the right thing. In other words, lawyers who were consistently on time, lawyers who got their judgments done, lawyers who were professional, were recognized. Oh, you're doing so well. If you keep it up, you're going to get a gold star. Mr. Fitzgerald didn't get one, and one of his partners did, and he's really mad about it. However, because he complained, we don't do that anymore. What I have done instead is simply compliment the lawyers. Mr. Chasson, thank you very much for your professionalism. Thank you for being on time today. Well, I see someone shaking their head. I had a special fixing one day. It started at 9 o'clock. Mr. Fitzgerald didn't stroll in until 11 o'clock. I had to call this lawyer and say, get a lawyer. So, you know, that is the problem. If you don't do what you're supposed to do, you don't get acknowledged. However, I don't give gold stars anymore.
All right, that's enough on
Well,
that.
I've got one last thing. He talked about there is no instantaneous testing. Again, if Mr. Fitzgerald practiced law right now, and he had looked at the forms for the Kids First program, he would see that people are now required to test within 3 hours of the order.
When did you stop practicing?
I've tailored down my practice to run. In March, whenever I made the decision, let me make one comment. I've never been late for any court proceeding in any court of the state or any federal court. In my world, the world of litigation, there's an objection called self-serving. That's what that is.
Would you like to see the
In
transcript?
terms
Guys, we're not going to get into
Well,
that
I mean,
kind
come on.
of silliness.
In terms of shutting down the practice, when I made the decision to run, that I made a decision with, again, my wife, John, that, you know what, if we're going to run, we're going to take this seriously. That point, I started actually referring cases out and or settling the cases or resolving the cases that I had as quickly as possible. At present, I have 2 or 3 cases that I'm still involved in. But every case that I would take the particular client, go meet with the attorney that I'm referring the case to get them up to speed, et cetera, and bring all the documents. And so that I'm very aware of all the rules going on. No partner of mine has ever gotten a gold star. My partner's Ronnie Cox. He teaches on professionalism. Trust me, Judge Ronnie Cox never had a gold star policy. But in terms of what's going on in the court system, I know intimately what goes on there.
Yes, ma'am.
Okay, I have a question. Say you were presented with a case, hypothetically.
Are you addressing it to me?
Both of you.
Okay.
But say you have the mother and the father. One of them pays, let's say the mother pays 100% expenses for all their children, whether it's extracurricular activities, education, everything. They pay for everything. They have joint custody of the children. When you go to make a ruling on child support, say the parent that doesn't put any money into the pot for any of this stuff, there's no ruling on child support yet. Say the other parent runs a cash business that they own, and so they don't really report much income, and they live a more extravagant lifestyle than the other party. They have more toys and playthings like that. What would you do to make a fair ruling on the child support judgment?
Okay. Well, if you're directing it to me, you can't, one of the things that we're prohibited from doing as judges is giving legal advice or giving specific legal rulings. How would you rule on X? But I will tell you, If you have that kind of case, what you would do is simply, gather all the evidence. If you are represented by a lawyer, y'all would go first to the hearing officer. And one of the things that the court or the hearing officer can look at is lifestyle. If someone is attempting to hide income, they look at all of that. So unfortunately, I can't give you a direct question. However, there is something called the child support guidelines that would have to be followed, and that's as best as I can answer.
Okay, actually, coincidentally, it's an issue I've actually lectured on, the hidden income. That it depends if a client came to see me, and again, the prohibition about a judge during campaign talking, it's been actually, you can't, in a particular case, give essentially, that your legal opinion on how you would rule, but I can tell you point blank, it's pretty simple, that if you do an income analysis, the attorney's not an expert, the attorney's not an accountant, not a forensic accountant. You'd have to get an expert. That is costly. So if a client came into me and essentially that their income was, if it was clear to me that they couldn't pay an expert $10,000, $15,000 to do that sort of forensic examination, then what I would do is I'd point to the labor statistics in Louisiana, which are admissible as evidence in court. So if you have somebody that's actually making less than the mean salary in that particular field, the court can actually impute then under the labor statistics what they should be making. It's very easy. It's not complicated. You don't need an income analysis. On the other hand, there are cases where if you have somebody coming in that makes a huge amount of income, he or she or together, then yes, it may be beneficial to have an expert come in. But child support, you have to always, as an attorney, you have to value the object at issue and dispute. In other words, that if you're talking about the child support guidelines, it may be a difference if you can prove an income of, increase it by $1,000, that may make $15 a month difference in terms of the ultimate child support award. And so so you have to be careful there. But a judge, again, that a judge has really three tools. Either that you could take the testimony as is. Number two, you can apply essentially the Louisiana labor statistics on income in that particular field. Or if there's expert testimony, you can weigh it accordingly.
I do have one. How you talked, and both of you talked on this, you've talked, and particularly yourself, Mr. Fitzgerald, you've talked about the children come first, and I understand that. But if you look at the news and you look at all of the situations that are taking place with NFL and everything else, sometimes in looking at the children, and I believe that that's important, we overlook either the wife or the husband, and most of the time it's the wife, where you've got abuse and these types of things. So the question to you is, how do you handle those situations in terms of addressing abuse to the wife in a relationship on that, and yet still trying to keep the family intact? This is for both of them.
Listen, it's not a family court judge. You had 5 questions for me on Monday that we went back and forth. I'll answer all your questions all night. But in terms of, again, it's not about keeping the marriage together in terms of family court judge. It's about protecting the kids. Let me tell you something. If there's a domestic abuse case and it's in front of me and there's evidence of it, a protective order would issue immediately. Okay? And the domestic abuser did supervised visitation at best. Okay? There'd be standing injunctions if he went around the wife. Jail. Period. It's not complicated. That in terms of but it goes back to protecting the kids. I don't want a domestic abuser having unsupervised custody of a child. That in terms of I guess I don't understand your question, but if it's when it comes to abuse,
how do you determine it to see that abuse is actually there?
Well, it has to be proven, like anything else in a court of law. If they meet their threshold burden of proof, or their burden of proof, in proof abuse, again, it's that. Let me back up a little bit. On Monday, when we had our first debate, the question was posed about spanking. And it gets to it. And I said, Theall gave her answer, and I said, well, it's a lot simpler than that. I said that if it's about protecting, for example, when you have a 3-year-old, you've been through that with a 3-year-old, you see them walking traffic, you bet I would give them a little spank with their tush. Because you can't explain to a 3-year-old, hey, don't walk in front of a street. It's about safety. As they get older, that I've come to realize that timeouts work better. And so but based on those life experiences, when a case comes to court, you realize what is over the top, what is too much. Did I answer it?
Susan, you want to?
I'm not real sure where Steve is coming from, but, you know, our jobs as family court judge is to look at what's in the children's best interest. The only cases that we are assigned are cases where there are minor children. So for instance, if it's an older couple with no minor children, that's going to go to one of the other judges. All we deal with are children. So our first job is to look out after the children's best interest. You're talking about looking out or trying to figure out what's going on with a spouse, whether it's a mom or a dad.
That's taking care of the child.
Okay, so for instance, there are a couple of things that lawyers do. They'll file something under what's called the Post-Separation Family Violence Act, or they may file a protective order, or they may file what's called an ex parte without hearing order of immediate custody. So what we see often in family court is parents who abuse spouses, and generally it's men who abuse women, and they do it in front of their children.
That's what I'm talking about.
All right, and so in those cases, you know, there have been instances where, again, we have suspended visitation until we can address the problem that the abuser has.
Okay.
We have a program called the Domestic Violence Intervention Project. We try to get people into that. There's a Best Dads course. I mean, we try to do whatever we can to give the parents the help they need so their kids don't suffer. Because if children witness violence against their mother, for instance, and it's two young girls, those little girls are going to grow up to think that it's okay to be beaten by men. If it's a little boy who's witnessed his dad trying to choke his mom or push her or cut her, they're going to think that's okay to treat people like that when they grow up. And so what we're trying to do is have an impact on the children's behavior, because we can, to some extent, control the parents' behavior. And
That's what I was trying to get at, is that you have the ability still to be able to control the parents relative to the children.
Right,
That's what I was trying to do from both of them. Okay. Thank you.
All right, I'd like to just, because we're running out of time, if each of you guys would, about 3 minutes, kind of a wrap up, and I will time you.
Go first,
All right,
Charlie.
Charlie.
I got to go first the first time.
Thank you all again for coming out. Thank you, Mr. Fontana, for having this. First time I met Mr. Fontana, I actually know his brother, who I'm very good friends with, and I couldn't believe his accent. And I said, well, I thought you grew up in Abbeville. And so then he explained that he was away from Louisiana for a while, and said that I love hearing some of the words that he says. In terms of the position, again, family court, again, there's two elements to this. And the reason why I would ask for your vote, it's experience. It's professional experience, and more importantly, the life experience. I think it's important, if you're a family court judge and you're making rulings that affect the well-being of kids, you're adjudicating their fate, you need to live with children as an adult, and you need to be a parent so you understand the awesome responsibilities and obligations that exist. We've been humbled by the support in the campaign process. And to give you an idea, Joe, you asked me about when did I shut down the campaign. I want to give you an idea of who I am. All the signs you see around, 450 signs, I put them up. These burnt cheeks, I go door to door. There's not enough sunblock that will protect my skin. The sweat takes it off. I'm committed to winning, but I need your help. And I'd appreciate your vote on November 4th. Thank you.
Mr. Fitzgerald is right. It does take life experience to serve in this position. I'm 57 years old. I have practiced family law for 29 years. And again, I've been a board-certified family law specialist for 20 of those years. I'm very proud of what I do. I've spent the last 3 years serving our community, and I want to continue serving our community. I don't have a family. I don't have children. That's a fact. However, I've handled thousands of cases as a lawyer. I see Dr. Ken Bouillon in the back. I've interacted with child psychologists hundreds of times over the last 29 years. I've helped with my nieces and nephews. I had my college-age niece live with me. I was her buffer. I'm what I call an action aunt. For those of you who are aunts, you know what it's like. I've been actively involved in my friends' children's lives also. So yeah, I've got some experience with children. But I also encourage you to remember that the other family court judge is male and I'm a female. I think it provides a good balance. I also believe that I have compassion. I know what children need because I've been in the trenches for the last 29 years. I ask for your support. I ask for your vote. I want to continue to serve our community. Thank you.
I want to just thank all you guys for coming, but I also want to thank both of you guys, because I know it is a lot. I know if I tried to run for office, I'd have to get rid of the Fontana Center before I could do it. So it is a huge commitment that you guys both made when you did this, and I certainly appreciate good people stepping up to the plate. So
Thank you for having us. Appreciate it.
guys, Monday at 2 o'clock here at the Fontana Center, we have Senator John McCain, Senator David Vitter, Congressman Charles Bustani, and Bill Cassidy will be here for about an hour to talk. So we invite you guys to come early, because I think there's going to be a large crowd.
Same format? You're going to have the same format?
No, they're gonna basically, those four guys are gonna be doing the talking, so I won't be doing it. And I don't know if they'll have time for questions or not. And then Wednesday, right? We have, remind me again?
We have a legislative update with Paige Cortez and Stuart Bishop.
And Stuart Bishop. They're gonna be coming to talk about the last legislative session we have. And then I've asked them to very specifically talk about Common Core, because we know that's going to be big on upcoming years. So you guys who are parents, want you to get here. If you're teachers, talk to the teachers, tell them to come here so these guys can hear firsthand about that stuff. And then we have one other one, October 22nd. Mr. Stutes is going to be here to talk about the DA's race. We have extended an offer for the DA, but he has declined to come, so, well, we have one of you guys, for you guys to meet. So we ask you guys to come and see what they have to say. Thank y'all so much, and be careful.